and the operational framework. This is the last point of this session about establishing the function. The operational framework. So we talk about the contract, which is the cornerstone piece of the operational framework, and other tools. We will discuss about how the contract is the framework, okay, for managing the contract. But then we will talk about the role of the manual and about other tools. So the framework for contract management is the contract, okay? It looks obvious, no? But it's very relevant to think about this so we understand to what extent contract management needs to be incorporated into the contract design from the outset. So the basis for contract management, procedures, protocols, etc., lies in the contract. In the contract in the wide sense, I mean, in the contract itself, but also in the bid of the winner bidder, which will be annexed to the contract, and in the request for proposal elements, because it's going to be also part of the contract. And we will discuss with some detail about some highlights. We will give some highlights about to what extent or for what particular things we need a contract or what should be incorporated into the contract. But first, let's discuss about a couple of things. The contract, to be a proper framework for its own management, must allow for changes and variations. So the contract needs to anticipate changes, okay? Because otherwise we will need to renegotiate. For the CP3P guide and for some countries like Australia, renegotiation is looking for a solution that is not contemplated or is not incorporated or contemplated, I think is correct, in the contract. We need to deviate from what is described in the contract to be able to look for that solution. In some countries, that cannot be done, mostly in civil code countries like Spain, for example. So how can be done? Renegotiation, by the way, renegotiation is something that is discussed in the course, but let me just describe a little bit. It can be done, but we need some kind of bill or law, some legal instrument that overrides the contract. Because for transparency, if something is not contemplated in the contract, I should need to tender out the game, to tender out the project again. To avoid this, the solution can be issuing a bill, a decree, which override the contract. And this is what has happened in many countries to deal with COVID. There was in Spain, for example, no? COVID, it was not contemplated as a force majeure event. In Spain, force majeure is a concept that is a clause, is respond to the Anglo-Saxon approach of a clause definition. It's just, it can only be a number of events. And if it's not, the event is not within that list, cannot be dealt with as a force majeure. So COVID affecting revenues would not be contemplated as a compensation event in Spain. However, everybody would agree that the spirit of a force majeure clause should include COVID. No? So in order to be able to be, because the Spanish government was, in that sense, as many other governments, accountable and proactive, decide to provide some compensations to share part of the impact, there was a need to create a bill, a decree. Otherwise, it could not be possible to implement the variation in the contract to accommodate a compensation and sharing the consequences of the COVID. That is an example of renegotiation, okay? So the idea here is renegotiation is, if it's needed, it's needed. It's not a bad thing by itself. But renegotiation creates problem with transparency. So we should try to avoid, to the extent that we can, renegotiation. For that, we need to be able to incorporate things that can happen, to foresee things and incorporate those changes and variation into the contract. So the contract management requires contractual flexibility, requires that the contract creates a framework that allows for modifications of the contract, but it's good practice in terms of a framework to have limits. So they say in the CP3P guide that we need bounded flexibility with some boundaries. Okay, we need to incorporate that flexibility into the contract. Also, a contract has to be document managed. Okay, dealing with contract as the framework for contract management, we need to recognize that there is a task to be done with its own sense, which is managing the document of the contract, different versions, etc. That is something related to information and document management. Okay, what instruments should a contract give me? What instruments should be defined by the contract that are needed for contractual management? What are the things that I am asking the contract to cover to allow me for this flexibility to manage threats, including changes, including claims, including dispute resolution, etc. So the contract and what other things are providing are being provided by the contract. We have a compliance framework, no? I mean, of course, the contract will describe what has to be done by the private. So we will have there, or we should have, a clear description of obligations and requirements, performance and service requirements, as clear as possible to be able to monitor the proper compliance with those requirements. That's obvious, no? And then we need information. We need to manage information. Information is needed to control the compliance, to control the performance, to put penalties. Okay, with respect to information, the contract should provide obligations of information and reporting from the private party. So this type of obligations are very relevant in a contract for contract management. We talk about what information should be provided by the private party that will help me to monitor the performance. Another thing that should be in a contract is the remedies, the remediation tools. The fundamental tool for managing performance is the remedies, the tools that I have that will act as incentives to avoid or diminish the probability that the private party is not going to perform properly or may breach the contract. This is absolutely crucial to be improved in a lot of contracts that we are seeing all over the world. We are talking about penalties, a description of the breaches and the penalties related, adjustments, especially when we are talking about payment mechanisms based in availability. In many cases, instead of an explicit penalty, it will be an abatement of the payment, an adjustment, a deduction of the payment because the guy did not meet with this KPI, which is a breach of meeting the minimum requirements in terms of outputs. We need room, legal room, power, ability, describe it in the contract, for dealing with a step-in by the procuring authority. I mean, one extreme situation of very poor performance could demand that the procuring authority take the control and directly manage the project during certain period of time. That is the stepping in, and that should be contemplated in the contract. And of course, what is the ultimate resource, the ultimate tool to avoid non-compliance and contract failure in terms of performance. Is early termination because of a default. So that's the ultimate resource. The resource has to be there, very clearly defined in the contract. How is going to proceed the procuring authority in a case like that? I mean, when do we have the right to terminate the contract? For what? A clear description of the obligations that if they are breached, I will have the right to terminate the contract, but the procedure of notifying the need to have there a remedy period, things like that, and the consequences of the termination. Okay, we can discuss about this if we have time later on. More things that I need to see in a contract: the remuneration mechanisms and other rights of the private party, the revenue mechanisms. They should be dependent on the performance. Okay, and the framework and rules for changes, for contractual changes, possible scope of the changes, types of changes in the scope of the contract initiated by the private party or initiated by the public party. They should have different protocols, different procedures. Changes in requirements, in the service requirements. What would happen? Can I do it? On the basis of what? We are talking about anticipating. For example, sometimes, I mean, of course, we need to anticipate that we may need to change a requirement, and we need to incorporate in the contract some procedures to change. But also sometimes we can anticipate a specific change in the requirements. For example, in transportation, we were discussing about this the other day. And transportation, in urban transportation, we know that we will have to change from time to time the service plan. Service plan is incorporated into the contract in terms of obligations by the obligation of offering or developing every year a number of kilometers, vehicle kilometers, for example, 100,000 kilometers to be operated every year with certain frequency, punctuality, and so on. Okay, but we know that from time to time we may need a change. So why not to accommodate the contract already for certain degree of change, so we don't need, under some boundaries, for example, plus minus 10% of kilometers per year that we could request additionally to the original plan, to contemplate already and cover the procedure to agree in the price for those additional service to be requested from time to time, putting a price from the outset to any additional kilometer with a limit of changing 10% of the original service plan. There are other changes that we need to accommodate in the contract, financial changes, for example, a change in the financial structure, allowing or not for a leveraging of the project, increasing the debt, and what is going to be the procedures, do I need to accept, what they have to submit, or of course, changes in ownership. We need to cover changes in ownership, transfer of shares, and so on, and which are going to be the conditions and things like that. And the risk allocation need to be incorporated in the contract so that the contract allows for relief for certain events and allows for compensation or rebalancing for certain events. Okay, we need a framework for that. The contract should capture and cover the risk allocation in a clear manner, including how to compensate events. Other rights of the private party, in addition to being paid timely or being paid for a claim that has a legal merit, for a compensation event, should be covered in the contract. Like what? Like a response for a request for authorization, for example, open to service authorization, rights to receive an approval or a rejection for a modification being proposed by the private party. The private party should have the right to being here in a dispute resolution board to try to solve disputes before going to courts, and other rights, of course, to cover the right to receive a compensation in case of early termination, depending on the type of reason or cause of the termination, whether unilateral, force majeure, or by default of the procurement authority, or by default of the very private party. So basically, these are the things that we should control that are in place in the contract to allow the contract to have to act as a proper framework for contract management. The manual. Besides the contract, we need a manual. The contract management manual provides a roadmap, just 5 minutes more, and then we have time for questions. The contract management manual provides a roadmap on how to manage the contract for any member of the authority. Okay? The manual will qualify the contract, but the manual will not replace the contract. The king of the contractual procedures and operational framework is the contract. But the manual is a good opportunity to develop further procedures that have not been foreseen in the contract or are not detailed in the contract, to clarify further any potential ambiguous provision for the sake of clarity. So we, let's say, settle in the manual the interpretation of that particular provision, for example. The manual should explain in clear terms what the administrator is expected to do when managing the contract. Development and contents. The manual should be written by members of the management team with some help from members of the project team and experts. The manual should be updated from time to time, in any case, for any contract change, and always for the permanent improvement of procedures. When we have the first version of a manual, we don't need to cover in detail the managerial needs of the whole life of the project, but to concentrate in the construction period. And then before, I don't know, 6, 7, 9 months before commissioning of the project, before starting the operational phase, and then we can develop the details of the next phase, the operations phase and the handback. A manual should follow a modular structure, and a modular should contemplate formats and templates by means of appendixes. Appendixes is a must to develop details, to develop specific issues. And very interesting, is considered good practice by European PPP Expertise Center and other sources of information to share the manual, at least parts of the manual, even the elaboration with the private party. Even when there is something that is not clear in the contract, with no intention of being ambiguous, and we use the manual to avoid that ambiguity, but the manual is not going to be binding on the two parties, okay? But we can use the manual to avoid that ambiguity and share that interpretation with the private party, because that is the spirit. This is my interpretation. This is not binding, but at least is providing proactivity and trust with the private party, sharing with them, listen, this is my interpretation. This ambiguity is from now is going to be dealt with in this manner. Okay, here you have an example of a structure of contents of one real manual that we did some years ago. It was for a transportation ticketing system of a city. So we had an introduction, objectives of contract management, background of the project, very important. Then a section about governance, which are the authority heads, the committees that we want to have, how is going to be communications and the decision-making process. Then a section for the authority team with an organizational chart, roles and responsibilities of the team of the authority, key contact points, the private partner team, the same, an organizational chart, roles, responsibilities, key contacts, I mean the name, the telephone number of the people. And then the meet, construction period. We cover with the certain details the governance for meetings with the private. We cover in a section obligations and monitoring. We cover approvals and authorizations that are needed from the contract authority, the contract authority feedback. A section about reporting obligations from the private party to the public party. Data and information management, a module about payments during construction. So always we are detailing further and in a practical manner, without legal jargon, what has to be done to manage the contract. Payments during implementation, of course, risk and claims, okay, commissioning, final approvals, of course, contract management issues, and dispute management. The core things of the material activities. And for service operation, basically the same, meetings, key obligations, and so on, but related to the operations, okay? And then a number of appendixes, map of obligation, the risk matrix, the risk register, and some templates. Templates like procedures like payment procedure, claim procedure, rebalancing procedure, things like that, okay? It's, for example, a protocol for updating every year the price to the actual inflation. Things like that can be developed in protocols. Okay, what about all the tools? All the tools apart from the manual and the contract itself. The information management system, which has to be built on the basis of the quality management system of the private party. Project management software, a payment mechanism model, an Excel or calculation book to deal with the specific calculations of the payment to be made every day with respect to the adjustments that we need to do. We need a worksheet to deal with that. A standard or custom software for performance data. And one of the key things, the financial model, is a very relevant tool to be able to manage financial aspects of the contract, especially rebalancing situations, compensation for events, okay?